News Network. I'm Heather Hansen here with Norman Williams, and we are continuing to wait for the openings in the trial against Quentin Tellis for the murder of Jessica Chambers. As we wait, we're hearing that the judge is now addressing the people in the courtroom. From what we understand about this judge, and I can't find my piece of paper with his name on it, but we spoke to a reporter local who said that this judge is especially strict, very much a stickler, has been on the bench for a very long time. And Norman, you and I were talking about that and the fact that they got this jury chosen. I think Nellie noted in the chat room, I mean, to pull off getting a jury in a capital case with this much publicity in one day is really quite unusual.
Very unusual. Very unusual. It wouldn't happen here, not that fast.
Right. I mean, you talked about it, 20 peremptory strikes. So that means that each side gets to strike 20 jurors just because they want to.
Just because they want to.
So that's a tough jury to get that quickly.
I believe so. I mean, let's imagine it was New York for a second. You know, one of the hardest things with picking a jury is you get person after person in New York that are sole proprietors of businesses.
Yes.
And for a long trial, which this will be, they usually will get excused. Now, the county that this trial is happening in, I can't imagine has the same level of population that we have here.
Right.
And I can also imagine that there are a lot of business owners, all of the local stores, any construction business, any consulting business. All of these businesses are probably owned by sole proprietors. And they do not want to be away from work. It doesn't matter what the case is and how important it is to the other side, or to each side, rather.
Especially those people who only get paid if they're at work.
Exactly.
Yeah,
I mean, if that happened to me, if I was on a long trial and I wasn't getting paid to be there, I'd be pulling my hair out.
Absolutely.
Luckily, I have a lot of hair to pull.
No, but you're right. I mean, that's something we often run up to when we're picking juries is hardships. You know, they say, I'm unable to come. And in a case like this, there's some real hardship. You've got to move away from your family. You've got to stay in a hotel. You've got to live with these people. And it's interesting, you know, sometimes judges can be very strict with hardships and say,
that's true,
unless you're, you know, going in for an operation, there's nothing that I would consider a hardship. I have to imagine that this judge had to have been relatively strict to allow for this quick of a jury.
Strict, I'm not so sure of, but bullying.
Well, that's another way to put it.
Bullying and suggesting to either side that they don't need to exercise their challenges. That does happen, but I think in general, in terms of most legal minds, there are two schools of thought on jury selection. And some say it really doesn't matter.
That's right.
The first 12 that get in the box are just as good as the 12 that come in the box by way of a lot of scrutiny. And sometimes that is very true. Yeah,
it's so funny that you say that because a lot of my cases have multiple defendants. And so we all sort of like, how do you want to do your, exactly. And everybody's got different kinds of charts they like to use. And I have a method that I like to use that's different than everybody's got their method. I know one guy that I work with a lot has a chart with a ruler and he really does all this mathematical thing. And ultimately I'm like, oh, come on, just put 12 people in the box and let's get a jury and get started. Because one thing I think people don't understand is we lawyers still get that adrenaline rush that by the time that you're ready for openings, you're sort of like chomping at the bit to get going.
No, it's
and
true.
I'm sure, you know, right now, as we sit here and talk about this case, calm as can be in the studio, those poor lawyers are probably pacing the hallways and going through their openings and making sure, maybe honing that opening argument. I know that's what I do.
Oh yeah, but I do that all night long.
Yeah, so, me too.
So when I walk into the courtroom, I'm trying to wake up and I'm trying to get ready and charged.
Yeah, that moment is there and ready to go. And then here, they're going straight into testimony, you know, and so from what we understand, Jessica Chambers' mother is going to be the first witness. We were, so tell us a little bit about what you think about that and what she may bring to bear on the case.
Well, if she has any information about what her daughter was doing, who she was doing it with on that day, she's a great witness, and she might be the closest to not being circumstantial. But other than that, I mean, if she had no interactions with the defendant at all, I can't see what the value of her testimony will be.
Yeah, I mean, you know, she certainly can speak to where Jessica was that day, or if she knows that information. And maybe also, you know, that reporter Ron Maxey who was on with us earlier today, he noted that it's such a small town that everyone knows everyone. So maybe she can speak to interactions that Quentin Tellis had with her daughter, and perhaps also to sort of preempt some of the defense's arguments about other potential suspects. Maybe that's her role as well.
Maybe. I mean, but if she doesn't know who did it, then she can't even preempt, really.
Right.
She can just guess. And she also can't testify to hearsay.
Right. Well, right, absolutely.
There's difficulties there, you know.
Yeah, it'll be interesting to see, you know, what she has to say and whether they continue with the line of family members before they get into some of the more nitty-gritty cell phone evidence and that type of thing. When you are defending a case and the prosecutor starts with the most heart-tugging, sympathetic, emotional witness, what do you do with that? You know, because you haven't yet established the rapport with the jury where they trust you. You know, over the course of a case, you establish trust, you establish credibility, the way that you communicate, the jury sort of feeds off of that. But first day, you don't have that yet. So how do you handle that?
You do and you don't. I mean, you can establish that during juror selection. You can get there. Right. And the jurors will sit there and they'll look at both sides, and they start to decide who's the better lawyer before the openings even begin.
Sure do. They sure do.
But you're right, though. It's that first witness, and it's an emotional witness. And the one thing that you hope for is that nothing hurts your client. And then you also take that deep breath and you say, 39 more to go.
That's right. Very good point. Very good point.
They won't even remember mom by the end of the trial. And people have kind of a preconceived notion of what a mother is going to say, or a father, or a sibling. I mean, so you expect mom to be emotional. You expect mom to kind of say to you, well, something was going wrong, and I kind of warned my daughter about things. You expect that.
Right, and the primacy and recency thing, I mean, that is something that lawyers specifically say, the first witness and the last witness are my most important. But to your point about 39 other witnesses, that's something that I think my mentor taught me, and I never forget it, that if you get one pearl from each witness, then you can string your necklace at the end in your closings. So you're not going to get a Perry Mason moment. With every single person, maybe not any of the people.
Right, and some people you're not even going to question.
That's right, and that's another thing I think that's really hard, especially for young attorneys. I know it was hard for me when I was younger, to realize that not speaking is sometimes a very effective way to represent your client.
Yes, it is. And look, if a witness doesn't hurt your client, the only thing that you're doing by questioning them is potentially heading towards the road of mistake, and depending on what your jury pool is like and how sophisticated they are and what their level of education is, they understand the difference between, oh, this lawyer just likes to get up and talk, as opposed to this lawyer is making sure that I get the information that I need.
Without wasting my time.
Because
when you've got a sequestered jury, you've got to be really, really conscious of not wasting their time.
Because they kind of feel like they're in jail too.
Absolutely.
I mean, that's probably the one advantage of doing something in New York. There's no sequestration anymore.
Right. Because it is, you can definitely have a jury angry at you, the lawyer, if you're repeating questions and they're like, we have this and we want to go home to our families and what are you doing here?
Oh, yeah.
That'll be interesting. Amanda in the chat room points out that Jessica had a phone call with her mother the night before the murder that may also come to bear in this testimony this afternoon from Jessica Chambers' mother. So that's a good point as to something else that we might hear from her. The other thing, Janice just pointed out that they may be going in the order of events. Now, when you're putting on your case, do you try to, I'll tell you what I do, but do you try to put it on chronologically, or do you take some other strategic?
I think as a prosecutor, you want things to be linear and you want them to be chronological. You want the story to make sense. You want each part to connect into the other. And one thing that I've watched prosecutors do over and over is when they putting on a chronological story requires every storyteller to be available when you need them. That doesn't happen in life.
That's exactly what I was going to say. When I say I tell you what I do, I just take who's available.
That's
because
right.
Especially when you're dealing with experts and people have lives.
They
and
have
so
lives.
they come in when they can come in. And
That's right.
part of your job as a lawyer is in your opening statement and in your closing argument to create the chronology for them, because you can't always take these witnesses chronologically.
That's right. And I've watched prosecutor after prosecutor apologize to the jury in their openings for the fact that things are going to be taken out of order. And that's not something to apologize for, but they do, because jurors think what they think.
That's right. And part of that is television.
Yes.
We're so used to seeing cases presented on I Love the Good Wife, for example, and things happen in a day and everything's in order,
Right,
and it's so nice, and they can go get drinks at night, and that is not at all how things really happen.
Like, I don't think that the average person realizes that the average Law and Order episode that's on for an hour, right? That hour is talking about years.
Years and years.
And
here, the investigation was something that was heavily covered. So we've heard bits and pieces of it, but now to actually have this 40 witnesses here on Law News covered gavel to gavel is going to be really interesting and really exciting, and really, we talk about the exciting part of it, but really hard for all of the people sitting in that courtroom on both sides who have been affected personally by this case.
That's right. That's right.
All right, we're gonna go to a break while we look and see what's going on in the courtroom. We will be back momentarily. The minute that they're live in the courtroom, we will take you live there. In the meantime, if you have questions, bring them on, and Norman and I will do our best to answer them. But we're going to take you to a break while we look to see what's going on in that courtroom. Welcome back to Law News Network. I'm Heather Hansen, and we are patiently waiting for the trial of Mississippi versus Quentin Tellis to begin. This is the case that involves the death, the horrific death of Jessica Chambers, who was allegedly killed by being burned to death. In fact, the case is a capital case. It is a capital case because Jessica was killed in the commission of a third-degree arson, and that therefore makes it a capital case. However, the prosecutor in this case, John Champion, has indicated that he is not pursuing the death penalty in this case. That's one of the many questions that some of us have had in the time leading up to this case. I know we've talked about it. The people in the chat room have asked about it, and that is, why are they not pursuing the death penalty in this case? We can't say for sure, though it does seem as though it's a situation that a lot of things weigh into that decision. The cost, the family's position on it. Norman, do you have any ideas as to why in a case like this they would not be pursuing the death penalty?
They may not be able to prove that it was a capital murder.
Yeah, I mean that is true. Although if they're able to prove their case, then you would think that they would be able to prove the capital part of their case.
Right.
I think that we had a guest on the other day who is very invested in capital cases and death penalty defense cases, and she mentioned that the cost of those cases, not just the financial costs, but also the emotional costs for the families, because there are multiple appeals and the process takes so long, that may be the reason. But
right.
We won't know until perhaps after the case is over. Perhaps John Champion will give us an interview here at Law News, or some of the defense attorneys as well. We do have some information on the names of the various players in this case. The judge is Gerald Chatham. He is, as I noted before, a very well-known judge locally. He's got a very good reputation, and a reputation for being quite a stickler. We have also found out that from live tweeting, I know for myself, when I'm unable to be here with you at Law News, I like to follow these cases on Twitter. There are no live tweeters going forward from the courtroom. The judge has not allowed any tweeting from the courtroom. So our own Kathy, I believe her Twitter handle is Kathy, I'll get it for you because I'm not positive on it. She'll be tweeting live, but we'll be covering it live from the moment that it begins, gavel to gavel. So your best source for information in this case is going to be right here with us. The defense attorneys are Darla Palmers and Alan Peterson are the defense attorneys in this case. We understand that they are public defenders, that is, paid by the local municipalities or the government to defend this case. Those are usually the types of attorneys that are assigned when the defendant does not have the means to pay for their own attorney. So they probably I would expect perhaps know the prosecutor in this case. Oftentimes these people work together often, though I'm not positive that this public defender is from the same area, the same county as the prosecutor. So that's something that we will find out for you, and something that will remain to be seen. The trial is expected to start any minute. There's been some talk that the judge was speaking to the jurors, the judge was speaking to the courtroom. We've also heard rumor that perhaps the defense attorneys were late. I can tell you that if I were in a trial with a judge who was a stickler, Norman.
Oh, you're there early.
Early.
Earlier
I mean,
than
I'm
early.
waiting for them to open the door.
Right.
The court staff often laughs at me because I am sitting there waiting for them to open the door. But gosh, so much better early than late.
Oh, yeah.
So we're continuing to wait and see. For those of you who are just starting to tune into Law News, we will be covering this case from gavel to gavel. That does mean we are going to have coverage later into the day. The case is it's supposed to start at 2 p.m. Eastern time, and so we are waiting for the trial to start. We will be covering it. We will be providing analysis. We will be providing insight from reporters who are there in the area, and we will be making sure that we have you covered. We are also going to be answering your questions. So if you want to join our chat room as you watch this case, we welcome you to do so. All of us hosts do our very best to answer your questions as we go, and we're going to continue to do so. We expected this case to start at 2 o'clock. It's now 2:30. One of my clients always notes that trial is often a situation of hurry up and wait. You don't want to be late for the judge, and yet oftentimes you're waiting for a juror or you're waiting for a defense attorney, whatever the case may be. So for right now, we continue to wait. We continue to see whether or not this trial will get started within the hour. I do anticipate that it will. I think if you've got a judge who's a stickler, he's probably going to give everybody some stern instructions as to whether or not they should be arriving in a timely manner and get this thing started as soon as he can. We do know that the first witness will be Jessica Chambers' mother, who had some phone calls with her daughter prior to the alleged murder. We also know that this case will involve, in large part, cell phone evidence. And we expect that the cell phone evidence placing, there you see Quentin Tellis, the defendant, placing him at the same location as the victim, Jessica Chambers, may be an important part of this case. The DA, John Champion, has indicated that he is able to place them in the same area in the hours immediately preceding the alleged murder. So we continue to wait for the courtroom to be live. We're going to take you back for a quick break, and we will be live in the courtroom the minute that we have the opportunity to do so. Welcome back to Law News Network. We're continuing to wait for some action in the courtroom. We've had a question come in from Maryland, which is a good question, and that is whether or not they're perhaps discussing a plea deal. What do you think, Norman?
They might be.
Yeah, but you mentioned something that made a lot more sense to me than they might be, which is, go ahead, tell us what you think the likelihood of that is given the allegations here.
Yeah, I mean, it's a dice roll, right? If he wins, he goes home.
Right.
If he loses, he dies in prison.
Yeah, I mean, it's not, it really, as you said, it's a dice roll, so why not roll the dice, especially if you are the defense attorney and perhaps looking for some publicity, to take your chances. In a case that seems pretty well stacked against you, if they win, they're really making a name for themselves, these defense attorneys.
Yeah, that's a good thing.
And these defense attorneys, our producer Kathy just informed me that they're from a different county, which is about 2 hours away. Now that's interesting to me because there is some parochialism in courtrooms. That is to say that judges who know prosecutors, and usually they know the public defender as well, and so everybody gets along. But when you have people coming in from another county who may not be as familiar with the judge, and especially if they were late today, that's not going to serve them real well, right?
It won't. But, it's just like anything else in life. You greet people with a smile and you treat people with respect, and things mysteriously happen in your favor.
I think that that's true, although I can tell you that sometimes you can go into courtrooms where the judge and the prosecutor work together a lot, and
that's
you
true.
step in as the stranger, and you can definitely have an uphill climb. We saw that to some degree in the War Machine case, where the prosecutor in that case was local. Jacqueline, Aaron knows her name, I know, and the judge obviously had worked with her quite a bit, whereas the defense attorneys came in from out of town. That can be hard for any attorney to be stepping into that type of a situation.
It can be. No, it's true. Like I've definitely appeared in other counties in the state, and I felt like a prosecutor is just looking at me going, what are you doing? Why are you defending your client?
Yeah.
Because
and
they're
you don't
so
know the rules, and you don't know the ways, and
exactly.
Every courtroom, there are some judges who hand out papers on the way that their room is handled. So it's, this is how we expect you to show up on time. At the beginning of my career, it was no pantsuits for ladies. Things have changed a little bit that way, but they can be pretty strict and pretty specific about no water at the counsel table.
That's right.
There's some pretty specific rules, and if you're there all the time, you already know the rules. You have a one-up.
Well, that's true, but also, too, usually rules are published. You can find the rules all the judges with quirky rules have those rules listed in their website, and usually it's one of the things that you'll see posted on a wall inside of the courtroom as a warning to those that don't read my rules.
Yeah, they get emailed to you, and you better check that email. I mentioned earlier that for following this case on Twitter, our producer Kathy is going to be tweeting it as much as she can. She's at CC Law News. That's CC Law News with a Z. So that's another way to be following this case. I know for myself, if I'm not able to watch on my phone, which I try to do as much as I can when I'm out and about in my day, checking Kathy's emails and checking Law News Network emails is especially helpful. We are still waiting for the judge to get this case started. No one's very clear on what's going on in the courtroom and what's taking quite so long. It is starting today. It is, Maryland's right. There's certainly the potential that they're having some plea discussions, but there's also the potential that there's just going through logistics. Kathy noted that the Chambers family is being kept in a separate room. I'm sure that they don't want the Chambers family interacting with the Tellis family, and there are Tellis family members there as well. So just setting up the logistics on the first day is a day like today. I know T-Bird, one of our chatters, used to work in a courtroom, and a day like today is very difficult on those people, the court staff, the court crier, the people who wrangle the jurors, because no one knows the process yet. By the time these 40 witnesses are done, everybody's going to know where to stand, where to sit, what the breaks are. But today is the day. It's sort of like first day camp, and you're first learning how everything goes and who's in charge and who you're supposed to listen to. So we are still waiting. No one seems to be in the courtroom yet, so we will keep you posted as soon as they are. In the meantime, we're going to take a quick break, bring on any questions you have. I would love to answer them for you if I can. Norman is more likely to be able to answer them than I, but we will do our best to bring on those questions, and we'll be back after this